What if a seller becomes incapacitated after the seller enters into a purchase contract for their property? So you have the purchase contract, the seller had capacity at the time they entered into it, and some event occurred that resulted in them becoming incapacitated and being unable to perform the remaining duties of a seller under the purchase contract. What are the options? So first, that contract is a valid and enforceable contract. So you have an enforceable contract. The question then becomes, well, how is that contract going to be performed? How is escrow going to close on that contract? And really, there's two options. So the first option is that the seller did some form of estate planning prior to their incapacitation and executed a financial power of attorney, appointing an agent with the ability to manage their financial affairs, which normally a well-drafted financial power of attorney would allow that agent to deal with their real estate, to contract on their behalf and sign deeds and other closing documents necessary to buy or sell real estate. And in that case, you should be able to present the power of attorney to the escrow company. And if the agent is willing to, act and fill that role, they can go and execute the documents necessary to close escrow. Now, keep in mind that there's what the law provides and what the title company will ensure. And sometimes they're not always the same, because title companies can be conservative and say, well, we need to make sure that this power of attorney meets our requirements or meets these certain requirements, or that the seller had capacity at the time that they signed the power of attorney, et cetera, et cetera, et cetera. And so they may, require additional proof, additional documents, items to accept and allow that power of attorney to be utilized. But most of the time, if the power of attorney is well drafted by an attorney, the title companies will accept that power of attorney and allow the agent to close escrow, even if the seller has become incapacitated. If there is no financial power of attorney, or the title company is not willing to accept the financial power of attorney, then you have to go into court and open a probate proceeding. And even though the seller is still living, just incapacitated, we still call it, at least here in Arizona, a probate proceeding. And somebody has to apply and be appointed as their conservator. Now, if the only reason you're appointing a conservator is for the purposes of selling real estate, we had Lou Silverman on a while back, and Lou discussed the idea that you can go in and just do a single purpose conservatorship, where all you're doing is asking to be appointed for the simple purpose of closing that transaction. And it's not as cumbersome, it's not as difficult, it's not as time consuming or costly to do that. However, maybe the seller is fully incapacitated and somebody needs to manage their financial affairs. And we're not just looking to close the real estate. We need somebody there who's going to basically take over their finances and deal with all of their, bills. And maybe they have businesses, maybe they have, other obligations, expenses that just need to be dealt with. In that case, then you're going to do a full-blown conservatorship, have somebody appointed. But once that person is appointed and the letters of appointment are issued by the court, you take those certified letters and you deliver them to the title company. And then that person that's appointed as, their conservator, their agent, has the ability then to close the transaction. So long story short, you have, if the seller becomes incapacitated after entering into the purchase contract, it's still a valid purchase contract, and you can close escrow if there's a valid financial power of attorney that the title company will accept, or if somebody goes into court and is appointed as the conservator for the seller, and they will then have the power to close escrow.
Sean, I think what is so important about this legal update is the fact that in estate planning, what often goes undiscussed is the planning leading up to death. Everybody talks about what happens after I die, but nobody thinks about the fact that estate planning ought to plan for events leading up to your death, right? And the difference between in just cost to appointing a conservator versus the cost of just having a proper power of attorney done to cover you in that situation is massive. We're talking about thousands and thousands of dollars, right?
Oh yeah, significant, because the thing with a conservatorship, especially if it's going to be a full-blown conservatorship, is you're not just hiring one attorney. So the conservator hires an attorney to go and file the probate, but then the court is going to appoint an attorney. We call it a guardian ad litem, for the quote unquote ward, or whoever is incapacitated. They have to have their own representation. And so you then appoint an attorney to represent them. So now you have two law firms that are having to be compensated as part of this process. And so once the conservator is appointed, they're expected to use the assets of their principal to pay for the attorney that represented their principal during the probate proceeding. So, the costs are significant versus a financial power of attorney. You're talking less than $1,000 to go and have that document prepared. Now, I don't recommend just going and saying, oh, well, for estate planning purposes, I'm going to go and just have a financial power of attorney prepared. I mean, yeah, you can, and people do. But at the end of the day, like as you pointed out, you need a comprehensive estate plan that deals with all circumstances, because it'll potentially save you thousands of dollars, whether that's, during your lifetime or upon your passing.